हाँ
हेलो। हाँ, हेलो हेलो हेलो।
एक आप भी बैठ जाओ सीट everyone stays here. Yes, where are I got some volunteers. ये क्या है? I'm asking you. Okay. You mean that every chairperson should get this. There's our minimum. You are also co-chair. She is also co-chair. He will not do it. Madam. Madam is very particular. For us, हाँ फोटो ऑर्डर आ रहा है बीच में कोई बढ़िया आ रहे हैं ना बराबर है ना तुम लोग भी बैठो ना जैसे कि यहाँ बैठे हैं आप यहाँ चेयर हो इधर कृष्ण यू भी डायरेक्ट ऑक्सफोर्ड से आप तो ऐसे ही आएंगे ना
गुड मॉर्निंग मैम Already, madam. Good morning.
Oh, good morning.
Good morning, sir, madam. Uma madam. Uma ma'am. Badra ma'am. Disturb नहीं क्या?
वीडियो चालू करा Now we can talk with him. Yes.
Unmute.
किती participants आहेत सांगा आम्हाला. Just say us. Who is the?
Ma'am, 30 participants.
They are paper presenters.
Pin करू ना.
But who are not paper presenters, can they be able to see online?
Yes, yes.
Who are online? They are there. So list. Paper presenters list.
केवल होगी सर.
क्या बायोडेटा इंट्रोडक्शन कौन करना है? क्या
Ma'am, this is
Can you start? Let us start, please. ठीक है सर. Yeah. Then Can I speak from here? Yes. ये हमें वहाँ जाना है. Recording के लिए बोल रहा था वहाँ से क्लियर. मैडम या तुम्हारे मोबाइल में कनेक्ट करके दो. Do you want us to sit over there?
No, ma'am. We can hear you.
You can hear.
Yeah.
Okay. Good morning, everyone. Hearty welcome to all participants and paper presenters in this 2 days international conference. We are starting with first session of 2nd September 2023. We have with us Dr. Naushikha Dora, Principal of Praveen Gandhi Law College. Dr. Kiran Sharma, Assistant Professor of KC Law College and former Head of SNDT University Law Department. Our colleague, Professor Uma Nehre, Assistant Professor at University of Mumbai Law Academy. We are happy to see all of you here in online presentations. Today we have 10 presentations and before 1 o'clock we have completed. So 3 chairmen are here for this session. We are lucky to have such 3 chairmen with cheerful faces. Yesterday also deliberations were going on and inaugural followed by speeches by international speakers. and one technical session is completed where Dr. Sanjay Jadhav was the chairman. And today we are beginning with our first session. Before that, we wish to felicitate our chairman, Dr. Naushika. Thank you, Naushika, for joining us. So many is gonna be. Now we wish to thank Dr. Kiran Sharma, Assistant Professor of KC Law College. Yeah, thank you so much. Welcome, Dr. Kiran Sharma. I appreciate her work. They are taking day and night efforts for making this event very good. Thank you, ma'am. Thank you. Let us begin with our technical session. I hand it over to next purpose.
Good morning, everyone. Good morning, ma'am.
Good morning, ma'am.
I'm Sabiha Badra. I'm Sabiha Isaac Badra, faculty at KC Law College. and I'm presenting my paper on role of judiciary in protection of environment and enforcing corporate social responsibility. May I start? Hello.
Yeah, please.
Yeah. Protection and preservation of environment has been a very controversial topic as every country is in the process of having its development, and as stated by the Stockholm Conference held by the United Nations in the year 1972, there is a need for sustainable development. But as every country has its own requirement and technological innovation is the need of the hour, so in that event, because of it, the environment is inadvertently un, uh, being degraded day by day. The courts are the only redressal grievance mechanism, but it was only after the introduction and bringing into force of the Environment Protection Act that the judiciary started to play an activist role. And it was, sorry, I missed out one thing. As the Constitution also did not have specific provisions for protection and preservation of environment. So after the 42nd Amendment passed to the Constitution, by way of the 42nd Amendment Act, two important articles were introduced into the Constitution, that is Article 48 capital A, which casted a duty upon the government, that is the state, and Article 51 AG, which was casted a duty upon the citizens to protect and preserve the environment and have compassion for living creatures. Now, after the process of liberalization, privatization, and globalization, there was an amendment to the Companies Act, and because of that, under Section 135 of the Companies Act, there is a provision that companies having the turnover up to 5 crores as well as more than that, compulsorily for the continuous 3 years, if they're having that achieving that particular turnover, compulsorily they have to keep aside minimum 2% of their profits for the purpose of corporate social responsibility, as they are taking from the society. They are duty bound to give back to the society. It may be in the form of any policies that they may have to how they should do the expenditure on how they should utilize the money, sorry, on completing that task of utilizing that funds which they have kept aside for the purpose of corporate social responsibility. The judiciary has been benevolent since a number of landmark cases to play as an activist approach and go beyond its work and do the welfare and take see to it that the environment is protected and preserved, that as it has been promised in the letter of the law, it seeks to enforce that letter of spirit and does whatever is possible for it by the landmark decisions. With your permission, I'll just like to discuss one or two case laws. uh, like for example, in the public trust doctrine case, that was a MC Mehta versus Union of India, whereby Mr. Kamal Nath was the Home Minister and he wanted to change the outlet of the river Bias. And when this matter was referred by Mr. MC Mehta to the Supreme Court, the Supreme Court levied the damages of rupees 10 lakhs, which was very less for the degradation that he had caused to the environment. There are many cases, landmark cases with respect to it. And basically, as the it is the court only which is the redressal grievance mechanism. So whether uh, whenever the matters will be coming before the court of law, the court of law has seen to it that it has tried to deliver justice as early as possible in the environmental matters. Ma'am, I'm done with it.
Okay.
Any questions?
Thank you. Next. Should sit somewhere in the office and then you should address. Okay?
Ma'am, should I follow from the title is Environment.
Hello, ma'am. There is a network problem in my phone. That is why I have come outside. I have joined from the mobile. That is the reason why, ma'am.
Sabia, it's okay, but one should sit at proper place and then address again. This is for another.
Ma'am,
present. Sabia, it's okay.
Okay. Thank you, ma'am.
Yeah.
Ma'am, if any questions are being asked to me, I'm not able to hear. That is why, ma'am, I have come outside, ma'am.
Arishi ma'am doesn't have any questions for you.
Gaurav. He's there.
May I proceed, ma'am?
Yes, yes.
I'm the next presenter. Yes.
please.
Good afternoon to everyone. Honored to be present my thoughts before this elegant panel of the members. Now my presentation is regarding my research paper, Climate Change and Global Food Crisis, Challenges and Prospects. Now, basically, considering this particular paper, I have some of the objectives where I am focusing on economist and agroecologist human rights perspective of the climate change as well as the global food crisis. Now, whenever we talk about the global food crisis, food prices has already risen at an extreme level and an extreme high. And so that's why I thought of presenting my paper on considering the causes of that particular food prices as well as its impact and effect of the climate change and overall concern specifically post-COVID period on such kind of an subject matter. Now, secondly, I also have to focus upon the hunger which is there because of the people do not have the purchasing power as well. And so because people are marginalized, people are discriminated against, people don't have food, and to bring all these particular phenomenon before the Food and Agriculture Organization, which is one of the important element or institution international platform where we are discussing all these elements. So in this context, I just want to quote Ban Ki-moon, who said that the food and the nutritional security are the foundation of the decent life. And so that's why we have to have the let there be bread aim, which is a fiat panis reflected in a Latin maxim. Now, the global food crisis is nothing but it's a wake-up call for an international community to think about the causes and prospects in that particular concern. And so that's why with that, I have come up with the hypothesis that the role of Food and Agriculture Organization is effective to curb the problem of global food crisis, as well as the world can achieve that particular aim of fiat panis, which is a Latin maxim, which says, let there be bread. Now, considering the time constraint, I wish to focus on the 14 pointers that I had written it with my research paper, where the first pointer it talks about rising of the food prices. Now, considering the world crisis and the reports presented by the Food and Agriculture Organization, FAO, United Nations, we have seen that it is in consistency in increasing the rise in the food prices. Now, whenever we go ahead with the causes of that particular factors which are responsible for food crisis, is one of the factor which is important is the effect of the food for fuel. Now, whenever we talk about the fuel or converting our petrochemical industry dependency to the biofuel industrial dependency, it is going to again cause an imbalance between the between the food that what we need need to eat, and the food which is we are going to use it for the fuel purposes. Now, whenever it comes to biofuel, we always say that in biofuel, there are huge subsidies in the United States and even in the countries belonging to the European Union. Now, when you have subsidized biofuel, so for example, consider the maize, which is the most important element that is used for the biofuel. Now, when I am getting the subsidies to have the crops regarding the maize instead of having the crops which are essential for the human life, then totally it is going to have its impact on the balance of life or balance of the food grains that we are going to have through the agricultural reforms. Then in addition to that, agricultural subsidies, which are reduced by most of the nations, is also one of the cause where people are now, instead of focusing upon the essential grain crops, etc., they are focusing more upon the such kind of crops where we need where we can have more, we can say, industrialization or globalization, where we need more of such kind of crops in that particular context. For example, instead of taking cereals, we are now moving ahead with more on ethanol based crops, where the basic elements which is to be used for such kind of biofuels is again the agricultural products. Now, one more important point is that an uncontrolled world population growth. Now, when we talk about the world growth, we always say that the China is the country who is responsible with the highest population. And so that's why they are the problem in context with a global food crisis. But whatever the reports that have been generated by the United Nations, they are of the opinion that whatever is the population of the China, they are self-sufficient and they are having whatever that they have.
Last 1 minute.
Sorry, ma'am.
Last 1 minute is remaining.
Yes, ma'am. Yes, ma'am. And so that's why in that particular context, increased demand of the resource intensive food shall be there. Now, decreased crops from the natural disaster because of the climate change is also one of the reason. Now, rising levels of ozone, where rising levels and depletion, both are going to have its impact on the final food products and the crops as well. And so that's why that is also one of the reasons where the climate change, global food crisis are going to have its impact on the violation of the human rights in furthermore. Coming to the last one point, and that is the financial speculations and the reduction in the world food stockpiles. And so this is also going to have its impact on the further prospects of considering the food, which is a basic fundamental rights, can get it violated with this particular concern. So with this, I wish to conclude my presentation. Thank you.
So much. Nice. Thank you so much for sticking to the timeline.
Yes, thank you, ma'am. Good day, ma'am.
Krishna, we are unable to hear you.
Our next
No, your voice is just coming and going.
participant is Dr. Keval Uke, whose paper title is A Critical Analysis of Media Trials and its Impact on the Fair Administration of Justice.
Okay. Thank you, Krishna Haripal. Good morning, one and all. Am I audible, ma'am?
Yes,
Yes,
very
sir,
much.
yes,
Yes.
Okay. Good morning, one and all present here. First of all, I would just like to thank each one of you to show your precious presence for this International Law and Research Management Conference on business environment, government and governance and sustainability, ethical practices and compliances in dynamic global market. I thanks to Dr. Aishri Varadi ma'am, Dr. Smita Shukla and Dr. Sanjay Jadhav for organizing this and organizing committee for organizing such a wonderful event, our International Law and Management Research Conference, what we can say. I acknowledge the presence of Dr. Naushika Duara, chairman of this session, and Dr. Kiran Sharma ma'am, Professor Uma Nehre ma'am, Dr. Nisha Kushwa, participants, organizing faculty members and the students. On behalf of Professor Dr. Govind Singh Rajpal, our Associate Dean Dr. Bhavna T. Kadu, myself, Dr. Keval Uke, Associate Professor from Sandeep University, Nashik. I really very glad to get this opportunity to showcase my views on today's our topic, that is critical analysis of media trials and its impact on fair administration of justice. I would like to share my screen. I have prepared one small presentation. Before I start, I will before I start, I will just quote one quotation. Someone has rightly said that we want to win. We want to win. Yeah, we want to win regardless of the truth, and we want to win regardless of the justice and regardless of who is guilty or innocent. So media is the most powerful entity on this earth to make the guilty innocent and the innocence into the guilt, as they control the mind of masses. I'll just share my screen. I'll just
You have a time limit of 7 minutes.
yeah.
Can you please proceed?
Window. Yes.
Will you summarize your main points of your paper?
Yes, ma'am. I'm just sharing the screen. 5 minutes I need to conclude, right, ma'am? Okay. Uh, I'll just I'm just going to summarize my this important topic: critical analysis of media trials and its impact on the fair administration of justice. That is introduction, media trials, double-edged sword, ethical and legal challenges, case studies, and real-world examples. Media regulations and guidelines, mitigation strategies and remedies, future outlook, and some recommendations with the conclusions. So, first of all, I will just start with the introduction, background, and significance of the media trials, importance of the fair trial in legal system. So, as we know that in today's hyper-connected world, media plays a pivotal role in shaping public opinion and influencing the perception of justice. So, media trials, a phenomenon where cases are tried and adjudicated in the court of public opinion before they reach formal legal proceedings, have become increasingly prevalent. Now, this paper presenting aims to delve into the intricate relationship between media trials and the legal system. So, examining their impact on individuals' rights, ethical considerations, and need for legal reforms to ensure a fair, balanced justice system. So, first of all, I just discuss that how the media is playing the significant role in shaping the public opinion and the shaping the public opinion. So, media trials have facilitated by the rapid growth of mass media, including television, newspapers, radio, and more recently online platforms and social media. So, these outlets have the power to reach a wide audiences quickly, making them influential in shaping public discourse. So the concept of the media trial is not limited to any particular country or legal system. It has become a global issue due to the widespread availability of information and case of sharing opinion on various platforms. So media trials can significantly impact public opinion about the case and the individuals involved by the individuals. No, so media trials can interfere with the principle of fair justice and trial. The intense coverage and the sensationalism of certain cases may lead to the juries, judges being influenced by the biased opinion uh, of the media and public. So, a fundamental principle of justice is that presumption of innocence until proven guilty, and media trials can damage this fundamental principle of portraying the accused as a guilty even before the court reaches a verdict, and which can lead to the irreversible damage to the reputation of the life of the individual. So the media pursued higher rating, profits can so the media's pursuit for higher ratings and profits can lead to sensationalism, distortion of the facts, and invasion of privacy. This raises ethical questions about responsibility of the media in reporting accurate and balanced information. So, importance we need to understand for this one, that what is the importance of the fair trial, in legal system. So, fair trial is the fundamental uh, fair trial is the fundamental principle of justice for a just and democratic legal system. It ensures the individual accused of a crime are treated with the respect, dignity, and in accordance with the principle of justice. So, fair trial is the fundamental
It's
Some maybe a network problem.
freeze.
Yes,
It's from your.
that's it.
और 1 मिनट वेट करना अदरवाइज नेक्स्ट
Yes, sir. Sorry.
May I call upon our next participant?
Am I audible now? Yeah. Hello.
Sir,
Problem something occurred.
just
sir, summarize your presentation in 1 minute.
Yeah, within 1 minute I will just summarize that. So that we can just see the ethical legal challenges are there. Some of the violation of presumption of the innocence, then impact of on impartiality of judges and juries, threats to the privacy and security of parties involved. That is right to privacy, sensationalism, and media accountability, social media's impact. Also, somewhere the manipulation of the public opinion and potential for prejudices. So, likewise, some of the I have also quoted in my paper some of the case studies, that is O.J. Simpson's trial in the United Nations states, where the football player, no, renowned football player who has been involved in the case of a murder of his ex-wife and his lover, no, wherein the media sensationalism created an impact on this case, and thereafter he has been acquitted from the court, no. So likewise, Nirbhaya case is there, Sanjay Dutt case is there, Sheena Bohra murder case I quoted, Jessica Lal murder, Nithari Kand, Ayodhya dispute, Arushi Hemraj murder case, wherein Arushi, she has been, her private life has been disclosed by the media. So likewise, many cases are there. Media regulations and the guidelines are there somewhere, which is in India and which is at the international level also. So Press Council of India, PCI is guiding somewhere. Then Cable Television Networks Regulation Act, CTNRA and the rules. Then programs and the advertising codes are there. Information technology, intermediary guidelines and digital media ethics code rules 2021 are there. Defamation law, further more to control these aspects, defamation laws are there. Contempt of court laws are there. Thereafter, international standards are also there. UNESCO journalism ethics guideline. Then Society for Professional Journalists, its code of ethics is there. Ethical journalism networks principles are there. The International Federation of Journalists (IFJ) is there, which is regulating this media
Sorry,
trials
time
and
is
its
up.
conducts. So likewise, many
Your
things are there.
presentation time is over.
Okay, so I'll conclude with that. The media trials presents a complex interplay between media ethics and the legal system. There should be a balance between right to information and the right to fair trial and the fair administration of law. Thank you.
Have any feedback?
Thank you so much.
We appreciate your collaboration with Ula, even though you cheated Kunali. Very good.
Thank you, ma'am. Thank
Yeah.
you so much.
We miss you here.
Yeah.
Yeah.
I'll come soon. I'll come back. Thank you.
No questions. Next.
May I call upon our next participant, Ms. Kavina R. Crasto, whose paper title is Intimate Partner Abuse and the Need for Cybersecurity, with special reference to revenge pornography.
Oh, that's interesting.
I'll tell her, no. Krishna, this is Tanvi who's next. Krishna,
Okay.
I'm joining from Savina's ID. I'm here.
Okay. Tanvi, you're on there. Tanvi.
So Tanvi is coming now. Oh.
Yes. That's a 4 in the list, no?
Our next participant is Tanvi Thakkar, whose paper title is Digital Transformation and Regulatory Framework with Respect to Online Gaming in India.
Thank you, Krishna. Good afternoon, everyone. It's glad to see Rajeshri ma'am and Kiran ma'am after a very long time. We've studied under them. So, as Krishna introduced, my name is Tanvi Thakkar. I'm a PhD scholar from Nagpur University, and I'm presenting a paper which is co-authored with my guide, Dr. Ms. Pratima Lokhande ma'am from Nagpur University. And like Krishna said, I would just like to reiterate on my topic. So my topic is digital transformation and regulatory framework with respect to online gaming industry in India. So connecting with the theme of the conference, here I'm presenting today my topic, my PhD topic, which is online gaming, and connecting it with the digital transformation. So digital transformation, as we all know, has impacted each and every industry nowadays. Digital transformation is nothing but employing the digital technologies to the traditional age-old methods which have been going on for in various industries. Like all the industries, the way digital transformation has affected all the industries, online gaming, or for that matter, gaming industry is no longer apart from that. When we play games, when we play normal games, is a very, very simple example of Ludo. First, Ludo was a cardboard or a physical game where we used to play with the dice and all, which is completely now changed to an online game. So that is a very simple and a very basic example of digital transformation affecting the gaming industry. In now, the question digital transformation has various aspects under it, and there are various new technologies which are coming up and impacting the online gaming industry, which includes blockchain, metaverse, artificial intelligence. All of these one by one have penetrated into the gaming industry and creating a new experience not only for the gamers, but also it also equally puts pressure on the gaming industries and the gaming companies to innovate and bring out new technologies to create a new experience for gamers or players online. Artificial intelligence, to give a very, very simple example, artificial intelligence is not only used for games, but companies have developing artificial intelligence even to develop games. Now comes the second and the important aspect of the research, which is how does the regulations or regulatory framework support these technological advancement in the gaming industry. So the Ministry of Information and Technology in April 2020, Ministry of Electronics and Information Technology notified Information Technology Intermediary Guidelines and Digital Media Ethics Code Amendment Rules 2023 on 6th of April this year, that is 2023. Before that, I would just like to enlighten on how huge or how big is the gaming industry now in India. Over the past few years, Indian gaming market has grown at an exponential rate and is predicted to surge to $5 billion by the year 2025. It is India has got the largest or the world's biggest biggest fantasy sports market, which with a user base of over 13 crores. So this has to be equally supported with a strong and a very robust regulatory framework. To regulate the gaming industry, government has appointed Ministry of Electronics and Information Technology as the nodal ministry. earlier this year, MET released draft amendments for the online gaming rules aimed at ensuring that online games comply with Indian laws and that users are protected from potential harm. Before this, there was only the Public Gambling Act of 1867, which governed the wagering and gambling in India. So there has to be a proper marriage that has to occur between the new laws and the gaming on the online gaming like Dream 11, Rummy Circle, all of these. So that is the area of my research. Any questions? So that is the brief on the article or the research that I've done.
Any questions?
Any questions?
At the end, chairman will give remarks.
Okay.
No questions here.
Yeah. Thank you, ma'am. Thank you so much.
Presentation. At the end of all presentations, chairman will give remarks. Okay?
Sure, ma'am. Sure. Yes, ma'am. We are here. Thank you so much.
Yeah.
Tanvi ma'am can, Sabina ma'am can also join.
Yes, yes, she's here. Yeah, yeah. I'll just pass on this to her. Just give hold on for a minute. She'll present.
May I call upon our next participant, Ms. Savina R. Castro, whose paper title is Intimate Partner Abuse and the Need for Cybersecurity with special reference to revenge pornography.
Good afternoon to the panel, which consists of all women. So it's very nice to see a woman-oriented panel. Yes. So in fact, my topic also today is on intimate partner abuse or intimate partner violence with special reference to revenge pornography. So we all know what intimate partner violence or abuse really is. It talks about any kind of intimate violence which is done to a partner in the midst of a relationship. This could be between married couples, unmarried, or even single, or even a person having a live-in relationship. So it includes all people who are a part of this particular relationship. Now, there are different forms of intimate partner violence, which includes physical, sexual, psychological, as well as stalking. So there are different forms of intimate partner violence. One major form of intimate partner violence is my topic, which is revenge pornography. Now, what exactly is revenge pornography? Now, first of all, we've all heard of the famous or rather the horrendous killing of Shraddha Walkar, wherein she was not only abused during her relationship, but also thereafter, even though everybody knew about the violence which she had faced, she was hospitalized. Her employer also knew about the violence, but still she could not get out of this abusive relationship, which then landed to her horrendous killing and led to she being cut into 35 pieces, which were thrown all over. So this is a part of your intimate partner violence. Now, revenge pornography is when there are certain kind of pictures or photos or videos which are taken at the time when you are in a relationship, and thereafter these photos without the consent of the opposite side are then transferred or shown to someone else without obtaining the consent of the person. So here what is important is the term consent. So consent which was given at the time when the two people were in a relationship, this particular consent is misused and these photos, videos are then circulated. And this was a live incident which had taken place wherein a 20-year-old girl, she found that intimate pictures of her genitals were unfortunately published in open. And then she had faced a lot of not only embarrassment, but also it led to severe mental trauma to her. So this is a part of revenge pornography, wherein people circulate images. Unfortunately, at that time, they are in a relationship, so there is consent. But thereafter, once or it may be because of frustration, or it may be with the intention to cause distress to the opposite side. So this causes a lot of trauma, not only it can also lead to people losing their jobs. So the effects of revenge pornography are vast. Now there is also a difference between cyber porn and revenge pornography. Cyber porn is what we normally see wherein you have a consent. There are models who are ready and willing to photograph themselves, and with consent such kind of photographs or videos are then published. In revenge pornography, the consent is there initially, but thereafter, when it is circulated because of frustration or because of revenge, these photographs or videos are then circulated, which apparently there is no consent for. So there is a very thin line of difference between cyber porn and revenge pornography. Now the effects, coming to the effects of revenge porn, they are huge. Unfortunately, in our Indian law, we do not have a specific law or a section, even in your IT Act, which deals with revenge pornography. And therefore, this is a subject of my thesis, wherein revenge pornography, though it is something which is to be seen in future, but still there is no law uh, to help the victims to get some kind of recourse to the legal provisions. So this is the thing, that either they adopt a particular section in the IT Act or they make a law by itself. As of now, if there are any cases of revenge porn, it only comes between or within the ambit of Section 66 of your Information Technology Act, which talks about cyber harassment and cyber stalking. So there is nothing else in the law which talks specifically on revenge porn. So this was my outline of my entire article, and it proceeds on this and it concludes with, of course, conclusions and suggestions. So thank you very much once again for giving me this opportunity, and I'm looking forward to more such kind of conferences. Thank you.
Okay.
Thank you so much, ma'am. Thank you.
Meghna Devkar for our next presentation.
Good afternoon, everyone. The entire panel who's sitting in today's conference has chairpersons and other people itself. My topic is on media trial, the constitutionality of media trial in India. A former vice president of the country had said, basically, he had remarked, the strength of the democracy depends upon the strength of each pillar and the way the pillars complement each other. Any shaky pillar weakens the democratic structure. Unfortunately, if you go to see, media is the fourth pillar of the democracy itself. And as it is said, fair is foul and foul is fair. So journalism today or media today can be compared, in fact, to a fun house of mirrors at a carnival, which is deceptive. Media plays a pivotal role in today's time, not only in India, but also around the world. And it has a huge responsibility of spreading and giving appropriate awareness among the masses of the people. In fact, under the Constitution of India, under Article 19(1)(a), it is very clearly said that freedom of speech and expression is a part of a fundamental right itself. It's guaranteed to the citizen itself. In fact, not only that, but media comes under the purview of Article 19(1)(a) to the various judgment of Indian Express newspaper versus the Union of India, then the Sakal newspaper's case itself. When we talk about Article 19, it states that freedom of speech. Everyone has the right of freedom of speech and also has right to even hold opinions without any interference, and the freedom to seek and receive any information and ideas of all kinds, regardless of frontiers, either orally in writing or in print or in any form of art or any other form of media of its choice which has been there. However, the freedom comes up with a restriction on the press that are special duties and responsibility and is subject to even the rights of the reputation of the others. The Constitution, no doubts, guarantees the right to freedom of speech and expression. But unlike the United States, the freedom of press is not expressly mentioned in our Indian Constitution, but it is only to the Supreme Court, the judiciary, who has recognized the fact that the freedom of press come under the ambit of freedom of speech and expression itself. In Hamdard Davakhana versus the Union of India's case, the right includes the right to acquire, the impart ideas and information about the matters common which has been there. Not only that, in AG versus the Times newspaper in the year 1990, also said that the principle on which the freedom of press was based basically is based on the principle of right to know. So the Supreme Court further opined in that particular case that the primary object for the function of the press is to provide comprehensive and objective information on all aspects of either political, social, economic, and cultural aspect which has been there itself. Media, no doubt, is being considered as a fourth pillar of it, but it is coming under the purview of certain operations under certain laws of it, like the Press Trust of India. It is being governed under the Press Trust of India, which is another thing. In fact, not only that, the Contempt of Court Act of 1971 also states that when a case has reached the court and in a pre-trial motion or individual or no publication is allowed to publish their own versions of the facts of the case, that is the publication of such fact which obstruct the interference of the proceedings of the court, which can generally harm the trial proceeding and which cannot be justified itself. The reason why trial media is not being allowed is certain reason, like it could influence the person who may appear as a witness in the court, or it may compel the parties to discontinue the litigation, or it could be prejudiced to the judiciary, and the public opinion could also affect the entire thing, and it may also inhibit other potential litigants from restarting to the law of the court which has been there. And that is where we have to take a note that the duty of the court is basically to protect the right, that is the accused, and most importantly the right to free trial. And every accused have a right to free trial without any hindrance. However, only when criminal or civil suits have been pending, only then it can qualify as contempt. So pending generally does not mean, it means over here that it relates to a commission of an offense when the charge sheet or a challan is being filed, or say when the court issues some summons or a warrant, or the case may be against the accused which has been there itself and everything. Now, talking about freedom of speech and expression and freedom of versus the freedom of fair trial which has been there. The right to fair trial is also a fundamental right guaranteed under, say, Article 14, 20, 21, and 22 of the Constitution itself. In fact, this is an absolute right. The right is an absolute right under Article 21, and it should be read along even with Article 14 of the Constitution. On the other hand, right to freedom of speech and expression is also a fundamental right, but it comes only within certain reasonable restriction, and as it has the interest of the sovereignty and the integrity of India and the security of the state which has been there. If you go to see in recent times itself and everything, in Kantogim, Kemi, Oj, Volunteer AB and others versus the state through CBI, the court had specifically stated that the prominence should be given to the accused right to a free trial with respect to the role of media which has been there. So, however, the right of fair trial is equally valuable, if not more, because the end of the day, a trial decides a man's right to life also itself, and if the justice system in our country is being influenced by the media, then it would be very difficult to understand that at the end of the day that it is not just and fair society which has been there. Further, when
presentation.
Pardon, ma'am?
Only 1 minute is remaining for your presentation.
Yes. Further, when we talk about the concept of media in media itself and everything, in Delhi High Court, in a Delhi High Court judgment in Sushil Sharma versus the state administration, the judgment it was being said that the judgment and the conviction will not be based on the media trial, but on the basis of the process of the law which has been there itself and everything. So in today's time, if you go to see, however, after that impact of the judgment, 70% of the today's population only relies on basically the media's information which has been there. And sometimes the media's information would actually impact the judiciary. No doubt in 2015, in Shreya Shingal versus the Union of India's case itself, the Supreme Court boiled down the element of right to free speech and expression itself, and it said that the freedom of press would be the very core and retreated the condition under which incitement, advocacy, or the administration of media trial can be sanctioned itself. And in 2010, in Manu Sharma versus the state, the Supreme Court referred that the nature of the entire judicial process, emphasizing on the importance of striking down media trials and providing the court with deserved respect and integrity to apply the course of the law of justice which has been there itself and everything. So, talking about the further thing, at the end, I would like to conclude that the judiciary and the media, basically, we need to have a balance of the entire thing itself, because unless and until information is not reached, a proper information is not reached to the public itself and everything, we cannot create a balance, and the judiciary should not be influenced by the thing. In today's time, people are more impacted through the media, specifically the social media, which is playing a most important role itself and everything. So when an information is being shared by the media, it should be shared in such a way that the public who is looking to that information will start thinking about it, that whether the information is correct or not. So if in fact, it is not a media's problem also. Even a common man should understand that before commenting anything, they should do a research and analysis of the topic on and posting in social media site. Thank you.
I told her, ma'am.
Yes, concluded.
Ma'am, your time is up.
Yes, concluded.
Ma'am, shall I start?
Four. Ma'am, Ashwini or video on.
May I call upon our next participant, Dr. Ashwini Ingole, co-authored with Dr. Sudhir Tarote, whose paper title is Greening the Legal Landscape, Environmental Protection Frameworks in India.
Yes, am I audible?
Yes, ma'am.
Yes, am I audible?
Yes, ma'am, you are.
Okay, so can I start my presentation?
Yes, ma'am, you can start with the presentation.
Okay. So good afternoon to all. So it's a pride to present this paper in front of such beautiful panel. Thank you so much. So the title of my paper is Greening the Legal Landscape, Environmental Protection Framework in India. So as far as my paper is concerned, the paper aims to explore the and analyze the legal framework governing environmental protection in India, with a focus on promoting sustainability and conserving the environment. The study evaluates the effectiveness of the existing legal regime in addressing environmental concern and achieving sustainable development. The paper begins with the overview of environmental challenges in India, tracing the historical backdrop that influenced the evolution of environmental laws in the country. The second thing which is to be focused in this paper, a critical analysis to key provision of the Environmental Protection Act 1986. The paper evaluate its effectiveness and the challenges faced in its implementation. When we talk about the latest position on environment in billion people, the high population density puts immense pressure on natural resources ecosystem, leading to issues like deforestation, land degradation, water scarcity, urbanization in another factors, which has been occurring at an unpredictable rate in India. And therefore, it has to lead to pollution of air, water, soil, as well as generation of hazardous water. And therefore, there is a need to enact some legal frameworks on environmental protection. And that's why our government took the initiatives by enacting the various legislations. So whenever we are talking about the enactment of legislation on environmental protection, the paper focuses on historical evolution of environmental legislation in India, that is the pre-dependence era and after the independence era. When we are talking about independence era, during the independence era in India, there was some early conservation efforts and legacies left behind by the colonial rulers. These efforts laid the groundwork for future environmental policies and conservation initiative in the country. After India gained the independence in 1947, the country underwent significant changes in its approaches towards the environmental management, leading to the development of more holistic and inclusive conservative strategies to address the diverse environmental challenges faced by the nation. Therefore, when we are talking about the post-independence period, variety of legislations enacted by the legislature, by the government, like Wild Protection Act 1972, Water Prevention and Control of Pollution Act 1974, Forest Conservation Act 1980, then Air Prevention and Control of Pollution Act 1981, Biological Diversities Act 2002, and the Environmental Protection Act 1986. We focused in this paper specifically on analyzing the Environmental Protection Act 1986. So if we analyze the Environmental Protection Act 1986, Section 3 of this particular act gives or empower the central government to take measure to protect and improve the environment. This provision of the act grants significant power to the central government to take measures for the protection and improvement of the environment. Again, when we talk about this Environmental Protection Act, variety of challenges came before this particular act. Like is not without the shortcoming. There are variety of shortcomings under the Environmental Protection Act. Like the act efficacy has been hampered by the challenges related to enforcement, inadequate penalties, and gap in its implementation. The lack of stringent penalty structure often undermines its different impact, allowing the environmental violation to persist. Additionally, the Act's breadth and complexity may contribute to inconsistent interpretation and compliance challenges necessities clearly guideline and increase the awareness amongst the stakeholder. So this act is also having some loopholes, some challenges, but despite of these challenges, India has also taken the significant steps to address the environmental issues. The government has initiated various programs and policies promoting renewable energy, afforestation, water conservation, and pollution control measures. Additionally, there is a growing awareness amongst the citizen, civil society, and the business about the importance of environmental conservation, leading to increased advocacy and sustainable practices. However, continued efforts and holistic approach are necessary to effectively tackle the complex and multifaceted environmental challenges facing by the nation. So this is nothing but the paper which I presented. Thank you so much for giving this opportunity to present this paper in front of such a beautiful panel. Thank you so much. Thank you.
Thank you, ma'am.
Thank you so much.
Friends are
तुम्ही just take करून द्या.
Thank you so much. Thank you so much.
कविता मॅडम ने बसव जरा माझ्या.
all the participants are informed that they have to conclude their presentation in 5 minutes as we are running short of time. Our next participant is Ms. Anushka Srivastava and Dr. Shikha Dimpri, whose paper title is Cryptocurrency Mines and Environment.
Good all. I hope I am audible to everyone.
We cannot see your video.
Am I audible?
Yes, you are audible.
It's for the technical glitch. I am having an internet connection which is quite with a lower bandwidth. My video would not be available. I hope that's. Hello.
गार्गी तुम लोग बाहर से।
Hello.
Yes, ma'am, you are audible. You can start.
So, may I start with the presentation?
Yes, ma'am. Yes, ma'am.
Okay, good afternoon.
One thing is,
The topic which I
Wait a
excuse me,
minute, ma'am. Wait a minute, ma'am.
what we suggest, since we are running out of time, instead of going through the PowerPoint presentation, can you please summarize whatever you have to present, because the topic looks very interesting. Okay,
okay, ma'am.
so just can you just talk about the balance between economic interests and ecological responsibility? Talking about cryptocurrency.
Keep it as crisp as possible. So the topic is cryptocurrency mining, mental impact that has in the country. So, the topic which we choose is to strike a balance economic interest of the country along with the ecological goals. Since after 2015 Paris COP21 agreement, India has implemented energy goals also. To attain the necessary for India balance, that not only economic innovation but also ecological.
She's from there.
Yeah, already.
So, this paper in collaboration with Dr. Shikha Dingri, such method which I have followed in this very doctrinal and analytical in nature. And India presently does not particular law when it comes of cryptocurrency. So basically, cryptocurrency could be understood as, and it's very difficult. The origin of such bit and the energy consumption, carbon emission that is associated with mining is of high in nature. Opinion is for a country like India, developing phase, either non-renewable resources to used for the mining of cryptocurrency, so that India economic growth and sustainability. So when laws that promote environment sustainability and governance in India, would say that the CSR regime is one of the most regime, and I'm mentioning that India is the first CSR in India. So when we speak of a program, a specific that deals with cryptocurrency, I am not mentioning that India has a regime so far. It has certain renewable energy policies that deals with production of clean and so basically what policies are, it is a set of machines and it operates.
Ma'am, can you please sum up your presentation in a minute? You have only 1 minute remaining for a presentation.
So basically, SDG 7, which specifically energy, I believe it the Indian government with certain programs, policies and schemes regulate the cryptocurrency industry in India so that the sources of energy could be by such industries and in both the economic growth and the sustainability. Thank you. That would be all.
Thank you, ma'am. Now I will call upon Dr. Sonali Kusur, whose paper title is Emerging Trends and Challenges of Women Entrepreneurs under Existing Regulations and Government Schemes in India. Yes, for a presentation.
But you said that she. Hello.
Am I audible? Hello.
Yes, ma'am, you are audible.
Yeah.
Hello. Am I audible?
Yes. Go ahead.
Ma'am, I have only 5
Yeah,
minutes.
thank you so much. Yes,
I have only
so
5 minutes for your paper presentation.
Miss Krishna, can I talk or hello?
Please. Yes, very strict student. Sonali, start your presentation.
Okay, okay. I thought I was supposed to.
No, we are looking at you. Yeah.
Okay, okay, fine. Thank you so
Are we
much.
not visible to you? Are we not visible to you?
Yeah.
Now you are.
Now, yes, now we can. Now I can see you.
क्यों बंद कर दिया?
गलती से हुआ होगा।
Yeah, yes.
Sorry,
Please go ahead.
Please go ahead.
Okay. Good morning, all of you. Rather, good afternoon, all of you. Special greetings to Rajshri madam and Kavita madam and other colleagues. Thank you so much for giving me this opportunity. I would like to present my topic on a very contemporary issue, the issue of women entrepreneurs. Presently in India as well as world across, the issue of empowerment of women is looked at from the economic perspective. It is no more that we are empowering women only with rights. We are also talking about how to build women such kind of capacities where they can support their livelihood, they can earn their livelihood. So women entrepreneurship is a key area which is also promoted at the international level when we speak about United Nations Women or other forums like National Women's Commission. A series of schemes have been initiated by the Government of India to promote women entrepreneurs. Here I want to talk about, since the time constraint is very less, I want to talk about few important issues which women entrepreneurs face. Right now, one of the best things with respect to women entrepreneurs, one of the contemporary legislation that has been very helpful for women is the recent Social Security Code 2020, as well as the Wage Code 2020. The present Social Security Code 2020 talks about a lot of social security benefits which can be given to women. Besides that, we have Unorganized Labor Act 2008, which also gives a series of opportunities for women to be gig workers and also self-employed. The category of gig workers or gig employment opportunity is very, very relevant, very, very pertinent considering women, because gig employment, which is also a part of the women entrepreneurship sector, where women can take up small kind of an activity or small scale activity. For instance, a very successful case studies could be the case of the Nestle in Gujarat, or the case of the small cooperatives which is there in Maharashtra, Lizzat Papad as well as in Gujarat. So these are some small scale entrepreneurship successful case studies, Amul, Nestle, or even the Lizzat Papad. So these kind of things can be categorized as small scale. Besides this, with the Unorganized Workers Act 2008, as well as the Wage Code 2020 and the Social Security Code, it gives a lot of opportunities for women to take up new kind of initiative and earn money and earn profits for themselves. Besides this, one important initiative which the government has promoted is the policy of doing of ease of business. This is another initiative of ease of business, which also facilitates a lot of other schemes under it. One of such scheme is the Mudra Yojana also, which is very, very lucrative and very good, having a very good coverage to cover women, especially the women who are coming from lesser or disadvantaged social, economic, educational background. One of the initiative under this Mudra Yojana is that they are not asking for a good amount of security or a good money deposit. Women can take up loans and they don't have to furnish security. This is one of the most biggest initiative, because then women can take the risk and women can bear the risk. Besides that, there are still certain challenges. One of the issues which women face mostly in order to become a successful entrepreneur or in order to climb any kind of economic advancement or achievements is the fact that there's a lot of lack of networking, lot of lack of coordination among women groups. We are yet to hear very few, if you see, women collaborations or women groups are coming together. The lack of coordination is one of the issues. The other thing is, while the government has only started Mudra Yojana, the private entities or the private financial initiatives are very less open to women entrepreneurs, because women are not known to be taking this risk and all that. So women entrepreneurs get lesser kind of opportunities, financial opportunities when it comes from the private sector. The third major issue with respect to women is the fighting their own social biases with the family and with others, because in our Indian societies, generally women do not come together from different families, different sectors to start their business together. So women are generally not the property owners. The issue of this is very few women in India, if we see the property
Ma'am, we
rights
have only
issue.
1 minute remaining for a presentation.
Yeah, this is the last point. The point being that women, by generally in the society, women, very few women have immovable properties in their own name. If we see the Indian society, for instance, if you see the tribal women, if you see any kind of rural women, very few women have immovable property in their own name. So that also restricts kind of an opportunity as compared to men to start any business or to take any risk. So these are some of the crucial challenges, both social, economic and others, and the challenges which they face from the labor market for the women entrepreneurs to come forward. Thank you so much for this opportunity. Thank you. I hope I'm within the time now. Thank you, Ms. Krishna.
Thank you so much for being precise.
Thank you.
Yes, ma'am, she was on time. Our next participant is Mr. Joy Shrikant Thakur, co-authored with
I hope I am audible to all because I can't hear any one of you. And my screen is also visible.
Yes, sir.
So, good afternoon, everyone. My name is Vishal.
Sir, you have only 5 minutes for your presentation.
I will just.
Ma'am, sir,
So-
you conclude your paper presentation in 3 minutes.
Briefly say, summarize.
Sir, please.
Okay. Emerging technologies for lowering the carbon footprint in the urban construction sector of India. India is one of the fastest growing economy in the world, currently the fastest one. And as the economy grows, the carbon footprint or the carbon emissions also increase. Currently, 25% of carbon emission of India is from construction sector. At the same time, it is one of the fastest growing sector because India is growing. So we did some literature review for how we can reduce this, and we come up. So we did this the way we did literature review. So I'll just keep it. And comes from construction sector in 3 parts. One is from the transport, second is the metal carbon, which is there in the material, and third is the operational part of the carbon. Then how we can reduce the carbon emission from the construction sector? First, we can use the low carbon material like green concrete, low carbon steel. Green concrete steel, it has a filler or it has a material like fly ash comes from the power plant and other fillers. Then we can use the clean fuel for making the cement or concrete or steel. In low carbon steel, we use more and more recycled steel. And to reduce the energy consumption we use during the construction and operation. But we can also have digitization, smart construction, like use of AI or the big data for better project management, better way to reduce the emission and all. Then we also have lots of existing construction. We can reduce the consumption by improving and improve the standard of living by installing solar, installing better windows, installing green roofs into the existing structures. I have already covered this. Okay. Then policies are very important. The policies which are either by supporting by incentive or by the regulation. So both with government is doing and it should be doing the same to reduce the carbon footprint of the construction industry or overall infrastructure development. So what are the national initiatives? We have the Smart Cities Mission, which promote the sustainable infrastructure. We have Amrit 2.0, Cities 2.0 for promoting circular economy.
Sir, you have only 30 seconds remaining for your presentation.
So I'll just conclude. So there are lots of opportunities in urban India for construction sector to reduce and move towards the green and more sustainable future. We have blue-green infrastructure, nature-based adaptation, and also the policies are also very important for reducing this, reducing the carbon footprint. And I thank all the organizers and the respected panel for providing this opportunity to present this. Thank you very much.
Thank you.
Thank you so much.
Good afternoon, each and everyone present here. Respected Rajashri Varadi ma'am, IC Director, University of Mumbai, Umla, and Professor, Department of Law, University of Mumbai, and my guru. Respected Dr. Smita Shukla ma'am, Director, Alkesh Dinesh Modi Institute of Finance and Management Studies. My co-chairpersons, Shika madam and Uma madam. First of all, I would like to say thanks to Varadi ma'am. She is my guru and she has been always reflected in her work of great leadership. Today, whatever the paper presented over here, we found the same feeling. All the papers presented were having a very good analysis, as well as they were having a particular theme which was very much fitting to the need of the society. Our co-chairperson is going to analyze each and every paper one by one. So I think I will not take much time. Once more, I would like to say thanks to Madam. She is my guru, Smita ma'am. Thank you so much for giving us this opportunity to present our views and hear so excellent paper presenters over here. Thank you so much. Thank you, everyone.
Hi, good afternoon, all of you. First of all, thank you very much for organizing this beautiful event. Thank you, Varadi ma'am. Thank you, Smita ma'am, for collaborating for this environmental and the need of the hour. The need of the hour is for sustainability. Most of the papers spoke about it. I figured out few things were missing, but then ma'am would be the right person to say about what the points which were missing. But then beautiful paper presentations, beautiful topics people have figured out. And thank you everyone for this beautiful event.
Now it is on afternoon. We started in the morning and now we are into afternoon. That shows that everybody, I mean, there was more than 12 papers, and in spite of the time limit provided, everybody is doing it. First, let me just offer my and gratitude to Professor Rajeshri ma'am. I was not her student, but my interaction with her is always there. So I'm really grateful to her for inviting me to be part of this initiative. Thank you, Dr. Smita ma'am, for inviting me, and to both my co-chair, Kiran ma'am and Uma ma'am. Coming to the presentation, I was looking at the papers presented and I was looking at the theme. And I understood that the environment, the word environment has been taken not to only to mean the business environment also they are taking into account, because when I was listening to the women entrepreneurship, so she was talking about the business environment and how the business environment is conducive to a women entrepreneur and sustainability point of view. So everybody is trying to fix into the theme of the conference. So I congratulate the paper setters for trying to pitch in their ideas within the framework of the conference. So I'll just take two minutes for, I mean, I'm not going to say everything for everyone. Some of the things, one paper that both of us were talking, in fact, Dr. Saurav's paper, Climate Change and Global Food Crisis, that has been like, we put here because connectivity was good. Everything was good in many of the papers, the connectivity was a different stuff. And the point that he has raised was very pertinent. And thank you, Dr. Saurav, for beautifully narrating the entire urgency of the food crisis that the world is facing, and the solution that you have offered like how we have to gear up our activities to deal with the global food crisis. Maybe you can incorporate the international provisions, like the rights that are given under UDHR and also under international covenant. If these two things are included, that will be more.
Sorry to interrupt,
Yeah.
but actually my name was not called out for the paper presentation.
You said no, not to take.
But now we are running short of time. So I think
Ma'am, but I've prepared it from yesterday and I've been waiting for my name to be called out.
no, we will take it after 2 minutes.
Yeah.
So then within 2-3 minutes, if you can address from then you can start.
Yes, sure, ma'am. I'll address it in within that time frame only, but thank you for giving me this opportunity. Sorry, really sorry I apologize to interrupt you all, but I really wanted to present this paper today.
Okay.
Thank you so much everyone for giving me this opportunity. My topic for today is the Paris Agreement and the global climate action that is taking place. It is with respect to the Indian laws as well as with the international laws. The Paris Agreement normally talks about the climatic issues that are going on all around the world. The agreement sets long-term as well as short-term goals that are there, which substantially reduces global greenhouse gases emissions to limit the global temperature. And it provides financing to developing countries to mitigate climate change and face all those issues. What I would like to address right now directly, since I'm running short of time, that the Paris Agreement actually help India as well as the international laws. So the international laws that are in support of this Paris Agreement are basically UNFCCC, that is United Nations Framework Conventions of Climatic Change, that support the Paris Agreement, whereas Kyoto Protocol, that is of Paris, that does not support, since it is the agreement that has come forward in respect to the Paris Agreement, and it addresses the climatic changes issues at a large, not only in respect to one country, but it is in respect to the world at large. The Paris Agreement plays an important role in our Indian laws, as well as we have a lot of environmental laws such as Environmental Protection Act, Air Prevention Control Act, National Green Tribunal Act, Forest Conservation Act, Water Prevention Act, and various other environmental laws are there. But even though today we have Paris agreements, we are the treaty who have signed this Paris agreement, and we have addressed the issues of climatic change. Today, if we see, India is facing a lot of environmental issues at a large. And even though this Paris agreement has been signed for today, but there are no amendments or nothing happened with respect to the Indian laws. So in the end, I would like to conclude that there is an emerging need that we need to change our Indian laws as well as the foreign laws. The treaties that are there present and that we have signed for needs to be changed, and the Indians need to go into the traditional background just to enforce the climatic and to protect our environment also. So I hope you all have got the idea, and I've concluded in within 3 minutes time.
Thank you so
I
much.
really apologize, but I had actually prepared it and I wanted to present it in front of the panel.
We appreciate your faithful presence. Yes.
Thank you so much, ma'am.
Thank you.
Excuse me, ma'am.
Yes.
Ma'am, just 1 minute. Actually, even I have prepared the article, ma'am, and because of the, I'll just take, ma'am, hardly 2 minutes. I'll take. I'll
No,
just.
see, 11 o'clock time was given to all in advance. So no one was here. Whosoever were present in line, we have taken each one. And now already 1 o'clock lunch time is declared. In other session, people are waiting for us that we have to join.
I understand, ma'am.
Ma'am,
Ma'am, I understand, ma'am. Ma'am, I just have one request, ma'am. I think this topic will really, this topic is really important. I think it should just reach to panel just for a minute or 2 minutes, ma'am.
It will take like this, no?
No, ma'am. It will take hardly, ma'am, like 1 minute.
नाम नहीं है ना, नाम नहीं है तो फिर आपके नाम रजिस्टर किया है क्या आपने?
Yes, ma'am. I have registered, ma'am. But the thing was, ma'am, ki My because of some
Presentation के लिए your research paper is not here.
yes, ma'am. Actually, ma'am, due to some time constraint, I
It's
couldn't.
okay, please don't interrupt them. Please, let her cover. Please, Chika.
I'll just quickly, because we are running,
Yeah.
you know,
Chika.
for time, yes, quickly I'll tell.
Sorry, Rajneesh. Some other time we will call you here and then please come personally.
Ma'am, all right, ma'am. All right, ma'am. Just one thing I just wanted to convey, ma'am. Like if panel would like to listen to the title of my topic, and then I think if you decide, I'll just not take more than a minute.
We can't take any
All right.
of the presentation.
All right, ma'am.
Sorry, Rajneesh.
No problem, ma'am. No problem. All right.
Yeah.
Thank you so much. I'll just take two papers together because it is like almost related here. One is both papers together, and I'm just covering, finishing everything. Okay, not covering the others.
Excuse me, ma'am. Ma'am, my name is Arjun Mochi.
I think you have to maintain the decorum. Now chairperson is giving her remarks. So please listen to her and do not interrupt like this. Please take proper action and in advance. Please. Shika, please.
Okay, so just we are running off time, so I'm just covering a couple of papers. Two papers I'm taking together. This is about media trials, and then Meghna has spoken about constitutionality of media trials. And only it has been nicely presented, very articulated. Only one thing I would suggest, of course, it is only a suggestion. Maybe you can take up two things like, Article 19(1)(a), Article 19(1) subclause A and Article 21. Both has to be read together when you're talking about media trials, because when you do a media trial, it affects the right of the accused, presumption of innocence. I mean, it will be nice if we can talk about that also. How the media trials affects the right of the accused also for a fair trial under Article 21. So if you get that, it will be nice. And then regarding this another paper, Dr. Oshini, you have spoken about what is the topic of Oshini, about foreign development, right? Something
this
landscape, yeah.
Greening of
greening the landscape, environmental protection frameworks in India. One thing that we have to, I was looking forward is reforestation idea and joint forest management, the participatory approach. So that will go a long way, because we cannot do everything only by legal intervention. If you're talking about protecting the mother earth, we need to have a collaborative effort. So through judicial intervention, only this participatory management, right? Joint forest management has come. So that particular point can be included. It's just a suggestion. It's up to you if you know. And apart from that, one was Dr. Shunali Kushul, who has spoken about business environment and women entrepreneurship. She has spoken about the self-help group, gig economy. And I will appreciate that she has tried to cover almost everything. And in India, most of the women entrepreneurs are self-motivated, and they have been trying to make a place for themselves despite all the limitations in the business environment with their self-motive. So it was a nice presentation. And apart from that, there was Paris climate change, which was presented in the last time, right? This was the only one, right? I think I have covered most of the topics. With this, I conclude. Thank you so much.
I request our director, Dr. Rajeshri Varadi, to present the certificates to the chairperson.
Along with Dr. Smita.
Along with our guest of honor, Smita Shukla madam.
We are not Ma'am, I guess so then you tell me. Ma'am, I Okay, one है यार एक, one हम इन बैठे आइए मैम and Kiran.
Mama.
One photograph, all kids who were organizing this. एक photo side कर लीजिए ना.
प्रांजल इधर आके
वो extra. बैठ जाओ photo side बैठे. कब line में
Ladies and gentlemen, I stand here today as a proud and grateful student to express my heartfelt thanks to all those who have made this event possible. I would like to start by thanking our college management and admin who have always been supportive of our initiatives and encouraged us to strive for excellence. I would also like to extend my gratitude to our teachers who have been our guiding lights, imparting wisdom and knowledge to us and nurturing our talents. Their unwavering support has been instrumental in our growth and development. I would like to express my appreciation to our guests and participants and the audience who have taken time out of the busy schedules to grace this occasion with their presence. Your presence has added an extra spark to this event and made it even more special. Finally, I would like to thank each and every one of you, my classmates and friends, without whose support, this event couldn't have been a grand success. Your contributions have not gone unnoticed, and I'm grateful for all of that you have done. In conclusion, I would like to say that this event would not have been possible without the support and hard work of each and every one of you. On behalf of the Legal Aid Committee, I express my sincere thanks to all of you.
All these young organizations. मैडम कहते हैं सबका साथ में.
Should I end this?
Now they are closing this closing this technical session. Closing of the technical session.
We would be soon closing the technical session, so I request everybody to leave the meeting.